Hello and welcome to another edition of On Our Terms, a video series by AIA Contract Documents. In this video, we're going to be talking about the owner's right to stop the work and the owner's right to carry out the work if things go wrong on a construction project. My name is Mike Koger and I'm joined by my colleague Jimmy Germano. We're both staff attorneys with the American Institute of Architects in Washington, D.C., and we work in the Contract Documents Department. As always, we can't give legal advice on this video, and nothing you hear in this video is a substitute for consulting with an attorney who is licensed in your jurisdiction who can talk with you about the specific issues you are facing. And with that, Jimmy, I'll turn it over to you.
Thanks, Mike. So let's get right into it. Today we're going to be talking about, in this video, the owner's right to stop the work, which is A201 Section 2.4, and the owner's right to carry out the work, which is A201 Section 2.5. And what we're going to do is we're just going to walk through the language of these provisions and kind of show you how they work, how they're intended to work, and maybe some pitfalls to avoid. So first, when you're talking about the owner's right to stop the work, it's important to understand what the triggering event is. And by the triggering event, I mean this first sentence here that is on your screen. So the Section 2.4 is designed to be triggered if the contractor fails to correct work that is not in accordance with the contract documents, or the requirements of the contract documents as required in Section 12.2. Section 12.2 is the correction of work provision. So that's the first potential trigger to the owner's right to stop the work if the contractor fails to correct work. The second potential trigger is if the contractor fails to correct, or if the contractor repeatedly fails to carry out the work in accordance with the contract documents, then the owner may issue a written order to stop the work. So it's important to understand with Section 2.4, it's not that complicated, but there are two potential triggering events that would potentially give the owner the right to issue a written order to the contractor to stop work. And I'm not going to go into the rest of this paragraph. It's a little bit out of the purview of this video, but just understanding that Section 6.13 is referenced there at the bottom, and that's the coordination of multiple contractors. So it's tied into that idea that if the owner hires multiple contractors, then the owner's right to stop the work may be affected a little bit in those circumstances, but that gets a little bit complicated. So next, let's talk about the owner's right to carry out the work. And this one is a little bit more complicated. You can see it's a little bit more dense. There's much more to it. So first, let's talk about this first sentence. So if the contractor defaults or neglects to carry out the work in accordance with the contract documents, so this is your first trigger, and fails within a 10-day period after receipt of notice from the owner to commence and continue correction of such default or neglect with diligence and promptness. So that is a mouthful. Now let's break that down for a second. So first, the contractor defaults or neglects to carry out the work, and then the owner gives notice. You have to wait 10 days, and then you have to evaluate whether or not the contractor has failed to commence and continue correction of such default or neglect with diligence and promptness. If you are at that period, then the owner may correct such default or neglect. It's a relatively broad statement. If you get to this point, it's important to understand that such action by the owner and the amounts charged to the contractor as a back charge, for example, are both subject to prior approval of the architect. So this sentence right here, it's important to understand that the architect becomes involved when you're talking about the owner's right to carry out the work in Section 2.5. It's important to keep that in mind, for example, if you're drafting a notice letter on either side from the owner or the contractor, and to understand that you really may need to get the architect involved early in this process. After that, the architect may withhold or nullify a certificate for payment in whole or in part to the extent reasonably necessary to reimburse the owner for the reasonable cost of correcting such deficiencies. So this is why the architect gets involved in this process, is to determine an amount that's reasonably necessary to back charge, for example, to reimburse the owner for the cost of correcting the contractor's deficiencies. Those costs can include owner expenses and compensation for the architect's additional services that are made necessary by the contractor's default, neglect, or failure. It's also important to understand that if the current and future payments are not sufficient to cover such amounts, then the contractor shall pay the difference to the owner. So in this situation, you can get, not only can current and future payments be withheld from the contractor, but prior payments to the contractor can actually, the owner can seek to get reimbursement of those prior payments. And then lastly, if the contractor disagrees with the actions of the owner or the architect or the amounts claimed as costs to the owner, then the contractor may file a claim pursuant to Article 15, which is your claims and disputes provision. I'm going to walk through a quick flow chart to map out this section 2.5 to show it perhaps a little bit more clearly. But before I do that, I want to pause for a second to see, Mike, do you have any questions, or do you think I need to cover anything more clearly before I move on?
No, that was excellent. I just want to make one little clarification. There's been at least one instance here where you've mentioned the word notice, I think maybe even in the prior slide, and the kind of notice that you'll need to do from one party to the other is all the way back in section 1.6 of the A201, and it requires that notice be done in writing. So just make sure you kind of cross-reference and go back to look at section 1.6 if you're trying to do this and provide notice in the proper way. That's all.
Sure, that's a great point, absolutely. And the interesting nuance, and we recorded a video on that point, and the interesting nuance there is when you get into claims type of notice or regular type of notice, that's the distinction we kind of talk about a little bit in that other video. So it's important to understand the difference, how they need to be delivered, to whom they need to be delivered. That's a fantastic point. Thanks for clarifying that. Mm-hmm. So let's go into a little flow chart here, and this will only take a minute, but it's important to kind of map this out, and it makes section 2.5 a little bit more clear. So it's basically breaking down the paragraph as I just did in a flowchart form. So first, I'm going to be using language that's similar to section 2.5, but it's not verbatim. So it's important to go back and check section 2.5 and check it in your contract, especially if things have been negotiated and they're different. But the first step is contractor defaults or neglects to carry out the work. Next, the owner gives notice to the contractor, and again, this ties into the notice provision, so go back and check out that video. Then you wait 10 days. After that 10-day period, the question becomes, has the contractor commenced and continued correction of such default or neglect with diligence and promptness? If the answer is yes, then your problem is solved. If the answer is no, then the owner may correct such default or neglect subject to prior approval of the architect. At that point, the architect may withhold or nullify certificate for payment to the extent reasonably necessary to reimburse the owner for the reasonable cost of correcting such deficiencies. And then lastly, again, if the contractor disagrees with the actions of the owner, the architect, or the amounts claimed, the contractor may file a claim. And that, in a nutshell, is a flowchart of how Section 2.5, the owner's right to carry out the work, works in real time. And with that, if you have any additional questions, you can reach out to us at the contact information listed on your screen. And if you like this video, you can feel free to subscribe to our YouTube channel and click on the bell icon so you get notifications when we upload a new video. And with that, I will turn it over to Mike unless you have any other questions.
No, that is perfect. Thank you.
Thanks.